All right, good morning, and welcome to the Vincent Davis Attorney at Law, CPS fighter. Welcome to our office hours. And if you are watching, go ahead and post your post your questions, and I will try to answer them. Welcome back to CPS Office Hours. I'm Attorney Vince Davis, and today we're talking about something that impacts almost every CPS case, and that is the reunification plans and process. If your child has been taken, or if you're working with CPS in any way, this topic is absolutely critical. A reunification plan is the roadmap to getting your child back. But if you don't know how to use the roadmap, you could get lost. Before we dive in, and make sure to like and subscribe to this channel, if the content helps you or anyone that you know in any way, we would appreciate your support to help us keep producing these videos and reaching more families. We need your help financially. This has developed into a whole staff of people that work on this project and these channels every day. And even a $5 donation would help make a difference. Down below at the ticker, it will show you how to make your $5 donation to our show. Okay, what is a family reunification plan? A reunification plan is usually a court-ordered or court-approved case plan designed to help parents regain custody of their children. It typically includes requirements like parenting classes, counseling, drug testing, supervised visits, sometimes some form of anger management or domestic violence programs. This plan is usually created by your social worker in conjunction with other professionals. But you do have the right to be involved in its creation, and the judge has the final say. And the court will monitor your progress every step of the way through the social worker. What to watch out for. Now, here's the tricky part of the reunification services and the reunification plan. Sometimes these plans are vague. Sometimes they ask for things that are nearly impossible to do due to your life, such as your job, your family, your location, or your lack of financial resources. I've seen parents required to complete 6 parenting programs that are only offered during work hours, or manage to attend therapy but given no referrals. If your plan has gaps and roadblocks, speak up and document everything. Remember, the plan is also a test. The judge and CPS are watching to see if you follow directions. But just because you miss a session or a test doesn't mean you're a bad parent. You have to show effort, and you have the right to request help if changes are required. So how do you fight back? If your reunification plan is unfair, you can request a modification. You can do that by either appealing it at the time of the disposition hearing being ended, or you can file what's called a 388 in California, called different things in the different states, but in California, you can file a 388 petition. You can get letters from your therapist, the teachers, or community leaders. You can show your progress in writing, and don't wait until the last minute before the 6-month review hearing comes up before you try to start challenging your reunification plan. Also, it's important for you to keep copies of all correspondence, make notes of every missed or delayed service, and keep a journal of your efforts. This becomes powerful evidence in court. I previously did a show and I spoke about reunification services, and I spoke about the importance of you getting a journal, sometimes just a spiral notebook from Walmart, and to keep track of all of your reunification plans, all of your involvement, what you've learned, etc. And I also recommended you emailing the social worker after every reunification service that you attend or participate in. Email them maybe the top 3 things that you've learned and how you're going to apply it in your life. Because what I get from a lot of people is they come to me right before the 6-month hearing and they tell me, Davis, I've done everything, and the social worker's not recommending that the children come home. And I do a little delving and I find out the social worker is taking the position that you've participated in your reunification plan, but you haven't gotten anything out of it and you haven't internalized it. Well, the burden's going to be on you to prove to the judge at the 6-month hearing that you have gotten something out of it. And what better way to do it is to show the judge the emails that you sent the social worker after each class, each counseling session, naming the top 3 things that you've learned and how you're going to and how you have been applying them to your life. Powerful evidence at the time of the 6-month hearing if the social worker tries to take the position that you have not internalized or benefited from the reunification plan. I'd like to share a quick story. One client I worked with was given a plan with 10 different requirements, which is quite a lot, some of which were impossible due to her medical condition. She documented every obstacle and requested reasonable accommodations, and she did this via email. We ended up filing a motion, and the court ordered CPS to revise the plan. Today, her child is back home. Had we not filed a motion to revise the plan, she would have headed to the 6-month hearing, not completed or participated in her reunification plan, and the child would not have been returned to her by the judge. In another example, a parent used my Fight CPS School, SKOOL, resources to prepare for every court hearing. He brought progress reports, showed up early, and took notes. He didn't have a private attorney, but he had the knowledge to advocate for himself, and he won his child back to his custody. So if you want some of these resources, please look at the school, CPS school that we have. Don't let a reunification plan control your life. Use it to your advantage. Document everything, speak up, ask for help, and fight strategically. And as I said earlier, if you need more help, you can give me a call at the number listed right there at the bottom right-hand corner, or you can join our school, skool.com. You'll get weekly trainings, live question and answers, downloadable templates, and a private community to discuss your CPS case with. And again, if you believe in this mission, please donate. We rely on viewers like you to keep the channel running. Your support helps educate parents, expose injustice, and reunite families. Now, I have a question from Facebook, and it wants me to go over the reunification process that I tell people. Okay, so if you're involved in any reunification courses, the most important thing is not that you showed up every week. It is to show the social worker and the judge that you showed up and you learned something. So the best way to do that is weekly. As you participate in each session, whether it be parenting, drug counseling, domestic violence, anger management, the drug testing, the visitation, after each one of those things, take the time and write a 5-minute email to your social worker. Tell the social worker the top 3 things that you learned from that class or that counseling session, and send it to the social worker. Oh, also include how you are or are going to apply that in your life. The reason why this becomes important is because at the end of the 6-month period, social worker is going to say you didn't learn anything. Therefore, I'm not going to recommend you getting your children back. Well, it's going to be hard for the social worker to do that or to say that if you come to court with your attorney and show all of your emails about the 3 things you learned at each session and how you're applying each of those to your life. Okay, it's very powerful evidence in court. I mean, first of all, the judge is going to be impressed because he or she has probably never seen that type of evidence in a CPS case. It's ongoing evidence almost on a daily basis. And you're showing the social worker and therefore showing the judge how you've gotten something out of the reunification process. In California, you're only supposed to be communicating about once a month with your social worker. That's all they're required to do. But if you're sending her emails 2, 3, 4 times a week about what you've learned and how you're applying it, it's going to be pretty damn hard for her to say, well, you didn't learn anything about the program. And in a lot of cases, I tell my clients, don't speak to the social worker without me. So you never really get to form that relationship with the social worker because you don't know whether the social worker is on your side or not on your side. Thus, if you do it via email, it's going to be hard pressed for her to say you didn't learn anything. All right. And you might want to go over your emails prior to writing them with your attorney and go over them with the instructor. Hey, instructor, today in your parenting class, these are the top 3 things that I learned from the class. Did I miss something? Oh, yeah, Vince, you missed this point and that point. Well, then you want to go back and before you write your email, you want to redraft it and then re-explain how you learned. By the way, when you interact with your instructors and your therapists in that manner, they will be impressed and they will be hard pressed to tell the social worker that you didn't learn anything, because they'll probably end up telling the social worker, well, yeah, Vince speaks to me after every class and we go over a couple things for clarification. I'm sure he's learning. I'm sure he's participating in the program. That's a key strategy that I hope you all participate in, because it's going to help you at the 6-month period, 6-month review periods. Okay. I am looking at the questions that are being posted this morning on Facebook and YouTube. Okima says, good morning. Good morning, Okima. How are you? Akima says, my retained attorney is on maternity leave. What can I do to adjourn the case until she's comes back in May, because the attorney that was assigned to me for coverage is a moron? Okay, Akina, unfortunately, you can't do anything if your case is in California. What you might want to do is consider consulting another attorney about what's going on in your case so that you don't miss anything while your attorney is on maternity leave. Kima goes on to ask, can you come on my show tonight as a guest? Please, please, please. Oh, Akima, depending on what time your show is, I can come on. You might want to call the producer, Grace, or contact Grace at vincentwdavis.com and see if she can arrange it for you. Kimberly from YouTube says, good morning, Kimberly. And Akima says, what if you completed all those services prior to the removal to stay 10 steps ahead of the game? Well, then, Akima, you're ahead of the game. And remember what I said earlier, completing the courses is not the key. You think that it is, but it's not. The key is showing the judge and the worker that you have benefited and learned something, as well as completed all the courses. Now, how do you do that? Well, I just explained that to you, how you can do it on a weekly basis, 3 and 4 times a week. You send in that email, knowing that your attorney and you will use that email at trial in court to help win your cases back. So write the email accordingly. Okay. Kimberly Eshman on YouTube says, what do you do if you have done everything and they lie to stop visits? Well, Kimberly, I just told you what to do. This is kind of prophylactic in nature. Now, if you haven't done what I've suggested, you're going to have to recreate all of that at the time of a hearing or a trial, and you're going to have to present that to the judge. You're going to have to tell the judge what you've learned. I was involved in a trial maybe 7-8 months ago, and the judge, after everyone asked questions, the judge turns to my client and start asking my client questions. The first thing the judge asked was, ma'am, what did you learn in parenting? Now, luckily, I had warned my client that somebody would ask her this. And I told her to memorize the top 3 things. There's magic in persuasion with the number 3. So she kind of went blank there for a minute. And then she said, blah, 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 blah. Answered the question perfectly. Then the judge asked my client, what did you learn in substance abuse? Which is a difficult question to answer, right? Well, she answered the question perfectly because she was prepared for the question. She said, well, I learned what my triggers are. And the judge said, well, what are your triggers? And she told the judge. Then she said, well, judge, and I learned that I can't be around the people that I socialized with because they were users. And the judge was like, oh, okay, well, you learned something. And then she said a third thing. Remember, there's magic in 3 for persuasive purposes psychologically. She named a third thing. And the judge concluded that she had participated in these programs and that she did learn something, despite what the social worker tried to say. The social worker said something, and in this particular case, she said that she hadn't learned anything. And I actually think the social worker might have meant it without lying about it, but she meant it because she didn't have a relationship with my client. She didn't speak to my client frequently enough to find out, well, I went to parenting and this is what I learned, or I went to substance abuse counseling and this is what I learned, or I went to domestic violence counseling and this is what I learned. By the way, domestic violence was an issue in that case, and the judge asked her, what'd you learn in domestic violence? Okay, and she named the top 3 things. And the judge even had follow-up questions, on the 3 items that she named. And she was able to testify and explain why those were important. Now, remember, this all happens in court. If you're not prepared and you don't know what to say, even if you did learn things, you're going to lose. So get with your attorneys and prepare for your testimony, prepare for the hearing. There's going to be a hearing tomorrow. The first hearing in what's called the detention hearing in California. And I forget what they call it in most states, but they call it, I can't think of the name, but it's the first hearing in the CPS court process. And the woman who wanted to hire me, but decided not to hire me, she's, still texting me. I'm still giving her information. And at one point she says to me in the text, why isn't the attorney that I hired preparing me for this hearing? I didn't know what to say. I can't tell you why an attorney you hired isn't doing what I suggest. Okay, there's different ways people practice law. I'm not going to tell you what I think is right and what they think is wrong. Okay, I'm not going to do that. Everyone has their own style. I'm just telling you how I win cases. And if you want to emulate or copy what I suggest, I think you'll have a good probability of coming out the way you want. All right. I've only been doing this almost 40 years. So, what I say as a 39-year attorney practicing, um, over maybe 37 of those years in CPS cases, it's going to be different from what a 20-year attorney tells you. It's going to be different from what a 10-year attorney tells you. It's going to be different from what a 5-year attorney tells you. So just know that we're going to be telling you different things because we have different experiences, different levels of education, and different levels of just pure experience in dealing with social workers, dealing with juvenile judges, um, and knowing what they might want to hear or like. I try to investigate every judge that I appear in front of. There are sites that tell you background and sometimes comments about different judges and how they rule. And you might want to know that before you go in. You might want to know it because in California, you can not agree to the judge at the first hearing and get a whole new judge. Okay, so there's a benefit to being prepared. There's an old saying that one of my bosses used to tell me, and I think it's called the 5 Ps: proper preparation alleviates the need for alleviates poor performance, something like that. Proper preparation alleviates poor performance, something of that nature. But you get it. You got to be prepared. You can't just walk into the court, not talk to your client, not do any legal research, not organize the facts, simple things, and expect to win. All right. I know, unfortunately, some attorneys take the position that you can't win at the first hearing, so don't worry about it. No need to prepare, which, by the way, is not true. All righty, let's see. Kimberly on YouTube says, what do you do if you have done everything okay and they stop your visits? Well, Kimberly, what you need to do is, first of all, sit down with your attorney. Secondly, you need to come up with a plan. You need to file a 388 to get your visitation back. You probably got your visitation stopped after you lost your family reunification services. And I've talked about this before. They do that so that you can't prove the bond between parent and child at the termination hearing of your parental rights, which would happen in approximately 120 days. You got to get the visitation back, Kimberly. Akima on YouTube says, I feel the same way, Kimberly. They stopped my visits as well as I completed everything. Okay, Akima and Kimberly, I've talked about this many times on this show. You can't win a termination of parental rights hearing unless you can prove that there's a relationship between you and the child such that it would be detrimental to the child, not to you, but to the child, to end that relationship. Well, in the 120 days between the termination of your reunification services and the 2-6 hearing, the termination hearing, if they stop your visits or if they cut back on your visits, guess what you're going to have a hard time proving at the termination of parental rights hearing? You're going to have a problem proving that there's a relationship between you and your child such that it would be a detriment to the child to terminate the rights. And the reason why they stop your visits or cut them back drastically is to tear that bond or any bond that did exist, to tear it down and tear it away. One of the things I'm a big fan of is when you lose or if you lose your family reunification services, immediately ask for a bonding study that you can use at the termination of parental rights hearing. Because at that point in time, if they try to stop your visits, if you do the bonding study early enough, that strategy of cutting back your visits won't work. You get it? If you have any questions, give me a call. 888-888-6582. Akima says, okay, they stopped your visit 3 months prior to removal. Well, that's just what I said, Akima. They did that as a strategy so you can't win the termination of parental rights hearing. All right. And notice they gave you 1 month of visits before they stopped you so that you didn't know what they were going to do. You didn't figure out their strategy. Akima says, they have taken my children out of state without my permission more than once. Akima, that they're not supposed to do that, but that's the least of your problems right now. You have to stop the termination hearing. Who cares if they took them out of state? That's not the issue right now. All right. Akima says 8 p.m. Eastern Time, 5 p.m. Pacific. Oh, your show is at 5 p.m. Pacific. Akima, call Grace or get in contact with Grace, and she'll try to set it up so that I'm on your show tonight. Little Nugget from YouTube says, I have court today, and I'm having the court set it for one of the days you had sent me. You have free for trial and get you retained well before the trial will be set. I will text you after court. Okay, Little Nugget, that sounds good. I don't remember speaking to anybody named Little Nugget, but that just may be your YouTube name. But Little Nugget, let me tell you this. People hire me every day, and my calendar gets filled up. So if you wait and think that I will be able to do your case on a date that we previously talked about, that's a real bad strategy. So if you're serious about retaining me, you might want to text me before the court hearing, and I'll have my secretary send some dates of when I can do trials, because almost every day my calendar gets filled up by people hiring me to do hearings and to do trials. Just don't think if you hire me the day before that I can show up and do your hearing. I can't. Too many people watch these shows, too many people hire me, and my calendar fills up. Okay, Dorothy Cook from Facebook says, if the investigation done by CPS finds the child safe in the custody of the parent, how can they remove that child from the parent custody they found the child safe in the custody for the same investigation? They can do it because they have that power and they have that discretion. Whether they're right or not, you get the right to have a court hearing. In California, it's called the detention hearing, and you can challenge that custody or that detention of your child. Last Monday, a week from today, I did a dependency detention hearing where 3 kids had been detained by the social workers and by the FBI who were raiding the house at the time. And we were able to convince the judge to release the children back to the mother. Now, that didn't happen by snapping my fingers and waving my magic wand. This lady hired me on Thursday, worked on the case Thursday, Friday, Saturday, went to court on Monday, and we were able to win. A little luck was involved, I'll have to admit, but a little preparation sometimes brings the luck that you need. So don't expect attorneys to hire them today and be ready to go to court tomorrow. They just don't have enough preparation time. NIP at YouTube says, good morning, Attorney Davis. Good morning, NIP. NIP, are you a member of my channel? Because your avatar is showing up with that different color, which means that you're a member. If you are a member of the channel, good for you. Email me and I'll have some special information and templates for you. Christina Reynoso says, Vince, are you an editor? Are you publishing anything? Christina, I have approximately 8 or 9 books that I've published. One of them is called The Secret, How to Fight CPS and Win. You can find it on Amazon. And by the way, I'm in the process of redoing that book and putting out the second edition. It's taking much longer than I had anticipated, but I published that book maybe 6 years ago. And I end up giving a lot of copies away. You don't have to buy it because I sell it on Amazon, and I think the price is like $9.99. And on every sale, I get approximately 40 cents. So I'm not going to get rich you buying that book at Amazon. So I just basically um, give it away, give digital copies away. And if anybody wants a copy of that book, call the office, 888-888-6582, and ask for a copy of the book. And they'll connect you with someone, or they'll just email or text you a copy of the book. And if you want the hard copy, the bound copy, I think they'll charge you like $4 or $5 for the shipping, but the digital copies are just as well. Akima says adjudication. I don't know what that means. Kimberly on YouTube says both are parenting and domestic violence. Said I blew them away with what I knew, and that domestic violence instructor was excited when I added her as a second counselor, and she let me know how she remembered me from classes. They sent me a parenting complicity eval who was given, it says, Fall's history, and then she herself lied in her reports saying she contacted my two therapists when she did not. Sounds like a civil rights case. Christina Reynoso on Facebook says, can you investigate a judge? Yes, you can. There are many sites out there that review judges. And if you talk to attorneys that practice before that judge, you can get valuable information. Kimberly says, they then hurt my son physically right in front of me, had a visitation, and I recorded it. They stopped the visitation and then continued to lie, and the report saying that I was the one that did it. Kimberly, it sounds like you need to talk to a civil rights lawyer. NIP on YouTube says, what's the website that I can look up judges' history? Well, if you're in California, all you have to do is Google it. How to investigate Judge John Jones, or what are reviews on Judge John Jones, and they'll take you to several different sites. I know one is called, I think, judicialwatch.com or something like that. So you may want to go to something, look on Google. Oops, I lost. Okay. Now the questions are coming in so fast I can't keep up with them. Kimberly says, okay, I can do that tonight. Little Nugget says, okay, Mr. Davis, I'll text you on my way to court. Sounds good. Now we have God on Facebook. God is greater than all CPS. Then has a cite to Psalms and Luke verses in the Bible. Says, what is it called if a judge assigns you, the attorney for DCFS, as the parent court appointed attorney, then realize she made an error, and then instead of assigning a court appointed attorney, assigns the parent as the parent's attorney, but the parent has no legal knowledge of how CPS court, no legal background, how is it legal at all? I'm not sure what you're asking, but you probably need to consult an attorney, get a free consultation somewhere. NIP says, yes, I'm a member. Thank you for being a member, NIP. If you ever have any questions, make sure you post and remind me, because your questions get priority. I'm Miss Perry, that is from Cal City. I'm on here almost every day for all the shows that I can catch, absorbing information to help me along this journey to get the babies home. Okay, NIP, I think part of being a member is you get some kind of free consultation. So call Grace. Email Grace, the producer, grace@vincentwdavis.com, and ask her to set up a free consult for you since you're a member of our YouTube community. Christina Reynoso says, I will pay you from check, a background before he was hired. Okay, Vince. Christina, I don't know what you're trying to say there. And then she says, please, Christina, I don't know what you're trying to ask me or tell me. And then Christina says, can I pay you? What were the charges against Judge before he did my family wrong? I'm not sure what you're saying, Christina. Christina, if you want to talk to me, call 888-888-6582. Set up an appointment to speak to me later today, because I'm not following you on what you're typing on your questions. Okay, we're well past the time for today. We're at the 35-minute mark on our 30-minute show. I want everyone to stay safe. Keep educating yourself. Keep watching my videos at YouTube. And we'll see you tomorrow. Tomorrow, come prepared with your questions. Write a question down and, email it to me or email it to Grace@VincentW. Davis. And before we start the show, I'll try to answer those questions. Okay? Or you can call, make an appointment for a phone consult by dialing 888-888-6582. All right, folks, everyone have a safe day. I'm on my way to the shower and then to court. See you tomorrow. Bye-bye.